Hey, friends. Welcome to Dishing on Divorce Tuesday edition. I'm your host, Lisa Lisser, CEO and founder of LZL Coaching, a boutique coaching firm focused on divorce, relationships, and life transitions. I'm also a divorced mom of 3 now grown kids, a recovering lawyer, a Jewish educator and spiritual counselor, and a divorce coach who is committed to transforming the divorce experience for everyone involved. We are listening today to WGSN-DB Going Solo Network Radio, podcasts, and TV. Divorce can be scary. None of us walk through the experience of divorce knowing what to expect. We have ideas based on what we've heard from other people, but we really don't know the ins and outs. And it's especially challenging when there's a special needs child who's part of the family. Who we hire to help us navigate divorce matters. And experts in the field of special needs and estate planning are essential keys to your success because of the unique needs of the special needs child, who hopefully will become an unemancipated adult. So many of my clients reach out to me at the beginning of the process and they want to know who to hire. Our guests today specialize in special needs law and emancipation, as well as long-term strategies to put in place while you're negotiating your divorce agreement. The information provided today is for informational purposes only, and nothing we say today is intended as legal advice or does it create or constitute an attorney-client relationship between Manes Weinberg, LLC, and the viewers and listeners. Please consult your attorney for any specific legal advice. And with that, I welcome Beth Manes and Cheryl Burman, partners at Manes Weinberg, LLC. Beth is a special needs lawyer, and her firm is in Mountainside, New Jersey. Her practice concentrates on estate planning, special needs planning, estate administration, guardianships, and contested guardianships. Beth services both Union County and Essex County on early settlement panels and is a member of the Special Needs Alliance, an invitation-only national organization of attorneys who help families with special needs. Beth frequently helps her clients and their divorce lawyers navigate many issues that arise with respect to their children with special needs, both during and after divorce. Cheryl Burman is also a partner at Manes Weinberg, and she concentrates on providing comprehensive estate planning, probate, and estate administration and guardianship services. One of Cheryl's passions is assisting clients in developing and revising their estate plans in response to changing life circumstances. Whether it's due to divorce, remarriage, or other significant change, she provides creative and thoughtful strategies for clients to address the needs of all their loved ones in potentially complicated situations. Additionally, Cheryl advises on estate planning and incapacity issues when clients are developing prenup agreements with the aim of anticipating and addressing commonly overlooked eventualities. Beth and Cheryl, welcome to Dishing on Divorce, and thanks for sharing your wisdom.
Thanks for having us.
Hi, Lisa. Happy to be here.
Thanks for coming. As we all know, divorce is complicated and filled with emotions. Each divorce is personal and unique, just as each family is diverse and unique. Special needs families often find themselves facing divorce, and they have different layers of complexity in their cases. I've had many clients who face divorce with special needs children, and in some cases, the children are adults. Some are emancipated, some not, but these divorces need to be approached with special attention to unique details, and you are the people who do that work. This is your area. So I want to start by welcoming you and asking you, tell us a bit about yourselves and your why. Why did you go into this field of law, and how does it resonate with your values? Beth, you want to start?
Sure. I don't think we have enough time for me to tell you the circuitous route I took to get here.
Okay.
The short version is, at some point in my life, I wanted to be a social worker, and I also wanted to be a lawyer, and the skill set sort of landed me here. It's the most social worky field of law I could find. And as a divorced person, I also understand the complexities from, a personal perspective. And, I've always been a good problem solver. So I like to say that I help people solve problems they never dreamed they'd have. So if we can do a little bit to make this horrific time a little less horrific, we try to smooth the path a little bit.
Wonderful. Wonderful. Cheryl?
So I've had actually a sort of circuitous route here also. I started my career actually as a tax/corporate attorney in New York City. And after many years of that, about 10 years ago, I decided that I wanted to, have a little bit more personal experience as a lawyer. And I wanted to help people a little bit more personally. And that's when I started at Manes Weinberg. And I started in the estate planning, guardianship arena. I'm also divorced, so I have a special understanding as to how difficult this time can be. And that's sort of where my passion in helping people in this circumstance grew from.
Yeah, I mean, I think that the circuity of our journeys is something that unites all of us. So I started in big firm litigation back in the 90s, and I stopped to raise my family and went into nonprofit leadership, which was a totally different area. But when it came time for me to figure out what my next career would be, I needed to do something more personal than dealing with big corporations. And so eventually it led me here to the divorce coaching work. But that's how we sort of redirect when life throws us curveballs. And
It's funny how we all had the same path or similar.
Because we each have our own divorce stories. So we know, and that gives us another layer of empathy and compassion for our clients.
Sure.
Which is really important. So tell me in broad strokes, if you can, what are the steps or considerations that a divorcing family with special needs children or a child needs to think about, and maybe like a step-by-step approach?
I think it really depends on how old the children are when they're starting.
Okay.
Oftentimes the children are younger, so you're looking at things aren't really on fire. It's not like, well, this child's 18 or even 16 and one person doesn't want to pay child support and the other believes that child support will need to be paid. So emancipation when the kids are younger, it's just sort of a provision in, a matrimonial settlement agreement. I'll just refer to it as the MSA, that, emancipation occurs on, and there are statutory factors. A child gets married, joins the army, graduates from, and maybe the parties tailor a little bit, whether it's college or graduate school. But at some point, that child will stand on their own 2 feet. It is
right. So just to be clear, emancipation means the parents would legally no longer be responsible.
Right. And, when your kids are 6, 8, 10, that seems oh so far away. And we're starting to see divorce lawyers incorporate language that, the parties acknowledge that, John, will name the child, has special needs or has disabilities. Maybe we'll describe them a little bit and may never be emancipated. And if they take that step, we would like them to take one step further and, discuss what emancipation for that child would mean. Because, we had one client come whose child was, diagnosed as autistic, was on the autism spectrum, but really a young kid, like maybe 7 years old. And the parents said, it's possible she's going to need support forever, or she may go work for NASA. We just don't know yet. And you can't know. So we want parties to contemplate things that might come up in the future.
That's the biggest thing, the what if, the what might happen. Cheryl.
Yeah, I was just going to say, and also, we've had circumstances where parties have gotten divorced many, many years before when the kids were young, like Beth said, and the child never took off, and they are still, they still have special needs and they still need a lot of support. And the party who was paying child support is very surprised that the child isn't ever going to become emancipated. And it's an issue that really needs to be discussed and addressed, maybe not finalized or decided, but at least a mechanism for when and how to decide so that one party isn't surprised that, emancipation doesn't happen.
So in that kind of circumstances, what a parent should do, or what a couple should do when they're writing their agreement, is say, our children are 7, 5, and 3. The 5-year-old has special needs. We will reevaluate the situation as the child ages, and maybe give a real timeline of when the reviews take place.
And another thing that might be helpful would be if there's a dispute about whether or not, how severe the special needs are and whether or not emancipation is appropriate, maybe they should put a mechanism in for how that's decided. They agree to hire an independent evaluator, or each choose an independent evaluator and have an umpire if those don't agree, but some sort of roadmap as to how this decision is made.
That's the key, I think, the word roadmap, because people really don't have a GPS for this, right? They don't know. They never expected that this would be their situation. That everyone, when they think about having children, has one image perhaps of what that is going to look like, but life throws in curveballs. And so, I had a child who was diagnosed with type 1 diabetes when he was 7 years old. So that changed the trajectory of how we approached raising the child, what his needs were. He adapted and we all adapted, but there are different requirements for different special needs. And that's something that when you're working on your agreement, you really need to have a little foresight and a little vision to the future, that things aren't going to be exactly the same. And we have to anticipate those things.
Right. And in addition to the roadmap, I always recommend a time frame.
Okay.
Because, the clock that's ticking, the alarm goes off on that child's 18th birthday when they technically, in the eyes of the law, become an adult. So you want to get some of these issues out of the way sooner. Maybe you say, as of on the child's 16th birthday or 17th birthday, that we start addressing it and follow the roadmap.
Yeah, that's a really appropriate way to structure, right? Like we have so many questions. When do we do something? How do we do something? So having a support team that shares that you have the ability to write into your agreement what it's going to look like. So let's take the steps that really anticipate and give you time to work through it, because there will be conflict, just because that's the nature of the beast. Right. But whether there has to be chaos, that's what we're trying to avoid.
Exactly.
And I think that it's important for people to understand why the concept of emancipation is important. When people think about divorce, there are really, 3 aspects to it, 3 main categories of things that are covered in divorce. I mean, first is equitable distribution. That's dividing of marital assets. The second is spousal support, and whether that's appropriate in a certain circumstance. But the third, which is a really important big bucket, is child support.
Right.
And emancipation really directly ties into child support. Because usually child support is only paid until a child is emancipated. With a special needs child, the child might never be emancipated. So that becomes a much longer payment stream, potentially, when there's a special needs child. But in addition to just the time of the payment stream, the form of the payment stream is really, really important also. A lot of times, in an MSA, they might, if there are 2 kids or 3 kids, they might say, oh, the amount of child support is X, and never actually apportion out what piece goes to which child.
Right.
When you have a special needs child, you can't do that. You've got to say what is allocated particularly to the special needs child, because again, if the child's not ever going to be emancipated, that's the piece that goes on, in perpetuity almost. I mean, until the child's death. The other reason is because if the child is ever going to be eligible for government benefits someday, benefits are often means and income tested. And child support after a child is 18 is deemed income to the child. So you can't just pay a parent child support directly for a special needs child who's over the age of 18 or could disqualify them for benefits. You need to actually have those amounts paid directly to what's something called a self-settled supplemental needs trust. And your MSA actually has to provide that it's in there because the requirement is that it has to be court ordered into that trust. So it's really that you have to think about these things at the time that your MSA is being drafted to make sure that it's done right so that you protect, the eligibility for benefits and the rights of your special needs child.
That is so important. Can you state again the name of that special needs trust that we need, just so we say it twice, we might say it 3 times because it's really, really important.
Absolutely. So the child support needs to be paid directly into a self-settled special needs trust or a self-settled supplemental needs trust. They both mean the same thing. And it's really important that the MSA provide that type of trust needs to be set up to accept child support payments. And it has to be incorporated as part of your divorce decree because it needs to be directed by a court order into that trust in order to protect the child's eligibility for government benefits.
And that's really significant if this is a situation that the child is going to need those benefits for the rest of their life.
Exactly.
So, Beth, did you want to add anything to that?
No, I think Cheryl covered it all. Again, and just to underscore it, because maybe we say it 4 times, that having it has to be irrevocably assigned. That's what the federal law says. So a court order does irrevocably assign it. So for the MSA to be incorporated into the judgment of divorce, that does the trick. For parties to say, well, we'll address it later. We don't know if child support's going to be paid. Better to, belts and suspenders now. You can always amend it later if you don't need it. But it's much harder when you're fighting the clock and Medicaid at the same time.
Yeah, I can only imagine. Well, that's a big point for us to take a quick break on, but we're going to take a 30-second break now to have a word from our sponsor, and then we'll be back with Beth Manes and Cheryl Burman. And we're back with Beth Manes and Cheryl Burman from Manes Weinberg, LLC. We're talking about special needs and divorce. Divorce with a special needs child. I'm sorry, Cheryl Burman. I apologize.
No worries.
I apologize. We're talking about the special needs trust. And I'm wondering, are there different kinds of special needs trusts that need to be set up for the child? Or is there like a catch-all phrase of what that really means?
So there are 2 types of special needs trusts. The first is the self-settled special needs trust that I previously referenced, and that is a special needs trust which is funded with the money of the child, and child support is deemed income to the child, so that's the money of the child. There's another type of supplemental needs trust called a third-party supplemental needs trust, and that's a trust that's funded by third-party money.
Okay.
So you would use these trusts in different circumstances. A third-party supplemental needs trust is often incorporated into an estate plan for a family who has a relative with supplemental needs. And the reason that you would want to do this is because you would never want to leave somebody with supplemental needs who might be eligible for government benefits and inheritance outright. Mm-hmm. That would be terrible for them because they might end up getting an inheritance that's not enough to support them forever. And then they would, not be eligible to receive government benefits. So when you are doing your estate plan and you have a relative with supplemental needs who you want to leave money to, you do not leave it to them directly. you create something called a third-party supplemental needs trust, and you leave what would otherwise be left to them directly to this trust. The trust can be used for their benefit, but not distributed directly to them. And there are a lot of, rules and regulations regarding the trust, but the most important thing is to know that you name a trustee and the trustee uses the money for them, and it doesn't hurt their eligibility for benefits.
So,
A first-party supplemental needs trust is the money of the individual, and it's similar, but it's treated a little less favorably, and it is not as desirable, because a first-party supplemental needs trust, you need to get approval for any expenditure more than $5,000 to any one vendor in a year. And most importantly, Medicaid has a lien at the end and has to get paid back for any benefits it paid. It pays on behalf of the person if there's money left in the trust at the end.
So then the third party special needs trust is really the functions more to benefit that child
Definitely.
than the first party special needs trust. So
Definitely.
these are all complicated issues that you need an experienced attorney when you're creating your MSA.
Yes.
When you are anticipating divorce and there is a special needs child, you should look to not just the lawyer who's been involved with your family for as long as you can remember.
Right.
You should find the expert, because
Mm-hmm.
you would never want to miss opportunities that could really harm the future life of this child.
A significant portion of our practice is fixing mistakes that have happened because somebody went to their trusted attorney and obviously that might not have been well versed in special needs. And although well-intended, things just didn't work out as planned. So there are ways to fix mistakes that are made, but they are most certainly not as desirable as doing it correctly in the first instance.
Right. Are there other things that people need to consider with respect to their estate plans to provide for their child with special needs?
The third-party supplemental needs trust is the biggest one.
Okay.
Definitely. Another one would be beneficiary designations, because what we find is that people do this beautiful estate plan that does everything the right way, but then they forget and they've named their 3 children outright as beneficiaries on their life insurance policy, or maybe a bank account, or their IRA, the 401k plan. And then, although the intention was there, you've directed money directly into the hands of the person with special needs, and you sort of thwarted your purpose. And then we have to go in and fix that also. So it's really important when you're doing your estate plan, whether you're getting divorced or not getting divorced, if you have a relative child with special needs, that you go to somebody who really is well versed in the special needs planning area. So that you cover, again, not just the will and the trust, but beneficiary designations and life insurance beneficiaries and retirement plan designations and all of that good stuff.
Yeah, that's really a lot to think about. But the thing is that anytime you're making an estate plan, regardless of your family situation, there's more to think about than you might expect.
Exactly.
And so, Beth, can you share maybe a situation where someone missed an opportunity to catch something and you came in to resolve that problem?
Yeah, I mean, there's one actually we're working on now that I was just thinking about, that in the MSA, we often see, that, one parent will have, each parent will have life insurance in the amount of $500,000 with the other parent as trustee, with no trust terms. So how do we know, what does that mean as trustee? For how long? What are the terms of the trust? What can the money be used for? And if there's a child with special needs, we really want to make sure that it's put into a specific supplemental needs trust, a third-party supplemental needs trust. We don't want it just out there in mom's name. So we're currently working on one of those where it just said in trust for, and the surviving ex-spouse and of the decedent and the surviving sibling of the decedent, who's the executor of the estate, are fighting over what's supposed to happen to that money. So again, they're sometimes just having us on, the Zoom call or in the room just to like raise the red flags and be the voice of doom and gloom to say, hey, what about this, is helpful. And there are less legal fees at the end.
Yeah. And there's less emotional stress and strain.
Right.
So much of what I do for my clients and what I hope I'm guiding them toward is reducing the emotional cost of the divorce and reducing the length of the fight. So if you're kicking the can and letting someone else deal with the fight after you're gone, that really defeats your purpose, right? You're not living up to that why of providing for. And here in a situation where it's easy in the course of a big settlement to forget some details, and having an expert on board, in addition to perhaps your divorce attorney, is the right way to go, so that you're structuring a settlement that's a business arrangement. It's really what it is. When I talk about co-parenting and I teach a co-parenting workshop, I share that your marriage relationship is over, it's on the shelf, but your co-parenting relationship is a business relationship. You are in a new business, and that is raising your children. And it doesn't have, you need to take away the image of fighting with each other so that all of your decisions are for the child. The child is at the center, and consider their response to the fights. So in this case, we're really thinking of people who lack the ability to even stand for themselves. So it's even more important.
Right. And we're often called in not by, one party or the other. Sometimes both attorneys will bring us in to have a conversation first with them and then with their clients. Sometimes mediators and judges who are mediating something will call us in so that we can be neutral. We're there just to tell you what's going to happen to your child. If we're post-divorce and we're litigating a contested guardianship, then, sure, like we'll advocate for one side over the other, but it's so much better if we can get brought in the first instance and help you resolve it so there isn't post-judgment litigation later.
Right. Because really people don't understand that it's not over when it's over.
Right.
So divorce has legs, and
Indeed.
I hate to say it, but it can last with the stress and the conflict for a long time. And the goal is to start at the beginning with a comprehensive plan that takes into account all different kinds of scenarios. You spoke about a situation where a child is 5 or 6 and is on the spectrum, but we really don't know which direction it's going to go. And so how do we plan for any eventuality?
Right.
Your statement, are they going to not be emancipated, or are they going to work for NASA? It's very real. It's not.
And this sort of segues into the whole concept of guardianship as well. I mean, before I said there are sort of 3 buckets in terms of divorce. There's actually 4 when I was thinking about it. There are 3 financial buckets,
right?
But then there's the custody issue and the parenting issue of the children. And when you have a special needs child, when they turn 18, the issue of guardianship, which is kind of like custody or similar to custody, arises.
I mean, it's really important because a special needs child may not be able to travel back and forth to different homes because they may need certain accommodations in any place they're actually living. So that may not make sense.
Right.
And so tell us a little bit more about guardianship.
So guardianship, like I said before, when you turn 18 and under the eyes of the law, you're an adult. I don't accept the premise that any 18-year-old is an adult, but alas, here we are. So when you have a child with special needs who turns 18, all of their decisions now become theirs. Education, financial, medical, vocational, residential, everything. They get to pick everything. They get to decide everything. If we have children with special needs who need more support in making decisions, we can go anywhere from, limited guardianship of, she just needs a guardian to make financial decisions to, plenary guardianship, full guardianship, where, the adult child doesn't have the capacity to make any decisions. And a guardianship, we need 2 doctors to certify what the person has capacity to do. And limited is always an option, and it's often an option. Jersey is very, very strong on people's civil rights.
Sorry about the dog.
We love dogs.
We do love dogs.
So I'm gonna hope we can speak above the dog.
Speak about the dog. So, we want somebody to retain as much capacity to have the ability to make as many decisions as possible. So if we have somebody with a limited guardianship, it doesn't mean that they're necessarily emancipated. One has nothing to do with the other necessarily. But if we have somebody who's, in their late 20s, who is, in college, but maybe is going to take a few years to get through college, is doing it with support, but we want them to be as independent as possible. We want them to be able to work. So if somebody is still paying child support, are we necessarily making this person in their late 20s abide by, a parenting time agreement? Aren't these the types of decisions people should be able to make, with whom they spend their time, what activities are they engaged in, things like that. So that's where it gets a little tricky.
Yeah, definitely. But it's about having the forethought to set that up so that you have a framework and you can write the same kinds of tiered details into a guardianship agreement.
Mm-hmm.
But it's something you need to be aware of right at the start and have specialists and experts working with you.
Yep. And it doesn't have to be all or nothing when you're talking guardianship. Even with both parents, what you both know, as after a divorce is final and as your relationship with each other and the children evolves over time, it might make more sense for one parent to be the guardian for medical purposes and the other one to be the guardian for financial purposes. And part of your agreement when they're young can be to address this and decide whether it's single, or some, hybrid thereof.
Right. Well, that's amazing. That's amazing to really, give people new ideas.
Mm-hmm.
Like, things don't have to be one way only. And I always encourage my clients to get curious and get creative and ask a lot of questions, and don't assume that your lawyer knows what you're thinking or what your questions are.
Right.
Because we want our lawyers to be mind readers and take care of us. And I know that, at least in my situation, I felt like I needed someone to take care of me after all this time of taking care of myself. And because of that, I didn't always ask the right questions. And it wasn't necessarily the best result. It was a fine result, but it could have been different if I had the courage to get creative and to ask questions. So I really thank you both for sharing your wisdom and your time with us, because you're talking about creativity, you're talking about having forethought, and you're also talking about getting the right experts on board early so that we avoid certain problems later. So with that, please let my audience know where they can find you.
Great. Thank you. Thanks for having us. We really appreciate it. You can find us online at www.manesweinberg.com. It's M as in Mary, A, N as in Nancy, E, S as in Sam, WEIN, B as in boy, ERG.com. Our phone number is 973-376-7733.
Great. And Cheryl?
I can be found at the same place.
Okay. I want to make sure. I just want to make sure everyone knows. Again, this is Manes Weinberg is a New Jersey firm, but the concepts we talked about today are for any family in any state going through this. Have the plan in place to think about the things you might not be thinking about. And I'll repeat again, the information that we provided today is for informational purposes only. Nothing here is intended as legal advice, nor does it create an attorney-client relationship between Manes Weinberg LLC and the viewers or listeners. Please consult your attorney for specific legal advice. And really, I thank you so much. These are such important issues, and we don't always talk about them. So I really appreciate your wisdom.
It was our pleasure.
Thank you. Thank you for raising the issues for everybody.
Thank you. And for my audience, you can find me at lzlcoaching.com. I love bringing important information out into the world so that you get some questions answered that lead to more questions. And that's our goal. So thank you again. And we'll see you next time on Dishing on Divorce.